These are the plaintiffs, Diana Crawford and Dan McDonald. They say they rented a 2-bedroom apartment from the defendant, and the guy infringed on their rights by forcing them to show the apartment to prospective tenants during COVID times, endangering their lives. And they're suing for the $5,000 they feel they're owed. This is the defendant, Barnett Brody. He says the plaintiffs notified him they were moving out, and he asked them to vacate a little early because another person needed a new place due to a fire at a different property. The plaintiffs agreed to move out. Now they turn around and sue him for $5,000 on some COVID protocol thing? Please. He's accused of lousy landlording.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiffs say their landlord is trying to jeopardize their health by showing their place to prospective tenants in the middle of COVID. Now, the defendant says the plaintiffs agreed to move out. He wanted to show the place under the strictest health protocols for the pandemic, and here they are. It's the case of pandemic madness.
Thank you, Douglas.
You're welcome, Yana.
All right, Ms. Crawford and Ms. McDonald, you used to rent a place from the defendant, Mr. Brody, correct?
Yes.
Okay, and you've come here to sue for $5,000 that you say he owes you. Why?
So upon many other issues with the unit, I had sent my landlord a notice of intent to vacate on June 26th. My lease was expired in July 31st of 2020.
Okay, and what's the relationship between you and Ms. McDonald?
She is my mother and co-signer of the lease.
Got it. So you notified him that you were not going to renew your lease, and you gave him the required 30 days, I guess, that you're, all right. So everything's fine. When do things go wrong?
So things go wrong immediately after I sent my notice to vacate. Afterwards, I received an email with a move-out letter. Typical instructions that we would get from a landlord on how to prepare the unit for the next tenant. I had no issues with it. However, number 8 clause of my move-out letter required me to prep for in-person showings of my unit. So, of course, we're in a pandemic. I had asked the landlord, is this provision still accurate? Is it still going on? Obviously, I don't feel comfortable having someone in my space during the pandemic, as well as having them come into my space and my germs. And that's when things went south. Immediately, it was just back and forth via email. The landlord just didn't understand why I had any concerns, didn't feel my concerns or my fears for COVID were valid. He mocked my fears of COVID, and he felt as if by me not wanting to allow showings, he was losing money on leasing to that next tenant.
Yeah, that's exactly how it works. I mean, that is a legitimate concern.
Right.
You also have a legitimate concern. It's COVID, and you don't want to have to let people into your apartment, but you call it mocking you, but it's actually a very legitimate concern. So I'm supposed to eat $825 because you won't abide by the lease. Because the lease does say you got to let it be shown. So
Correct.
Civilized human beings would work this out. There has to be a way that could happen with everybody being comfortable. Did anybody talk about a way for it to happen with everybody being comfortable? And what was the suggestion?
We had asked the landlord if he would be willing to hold showings until July 26th.
July 11th. Well, July 26th? How was he going to rent it out in 4 days?
Right, so that was
5
at
days.
First. So we had pitched that at first to give a week worth of showings. Of course,
no, that's 5 days. That's
like,
not a week. That's not a week. That's 5 days. So then what happens?
So we had asked him if it would be okay if then I vacated by the 11th, completely left the property, took all my belongings. Would we be able to compromise and allow the in-person
Okay, that's not so, that's not so bad. Mr. Brody, what about that? Why wasn't that acceptable?
First of all, I don't recall this part of it, where she brought up this element of the 11th. I am reviewing...
Okay, so hold on. Let me show it to you because it's right in an email. She writes to you on June 26 at 6:32, I have a health condition that puts me at risk for coronavirus, and my fear of contraction is very real and can result in my death. Social distancing and mask precautions do not protect an individual to the fullest extent. I am not asking you to not show the unit. I am asking you to wait until at least July 11th, the apartment would be cleaned and presentable for showings. So she did offer that. And why wasn't that acceptable? You just didn't want her calling the shots, or?
By June 11th, the pool of people who are going to be moving in for the next month are gone. The way nobody's looking to move in.
You feel by the 11th? I mean,
I feel
that is, you know,
my flow by a huge amount.
He's reduced his pool of the people who potentially might rent it by 11 days. But also, Mr. Brody, we have a pandemic. So was a suggestion ever made that people would wear masks when they came in?
So we had eventually, going back and forth, I had asked the landlord, will, PPE and mask be required? He actually told me that CT and New York had no mask mandate at the time. And although he could suggest to prospective tenants, although he could suggest to prospective tenants to wear a mask, he will not enforce it.
Okay. And he suggested that you just exit the apartment.
Yes.
During showings. And you were not comfortable with that because?
I worked from home full time at the time of the incident. So I was unable, and I host live trainings during my job, so I was unable to leave.
Well, you're able to leave. You set up somewhere else with a mask and a computer, and it's not true that you're not able to leave. But Mr. Brody, why wouldn't you just say, I'll have prospective tenants walk in with a mask?
These emails that we're reading are on June 26th. The June 26th, that was the beginning of it. It then continued where Gladys had verbal conversations and she agreed to wear a mask. Yeah. In the beginning of the conversation, first of all, also
and to make the tenants wear a mask, because there were emails where you're saying, I will absolutely not make the tenants wear a mask. Prospective tenants wear a mask. So was Gladys offering? Gladys is who?
Gladys is the property manager who conducted the showings.
I'd like to talk to Gladys. Thank you, Gladys. Can you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, Gladys, you're the property manager?
Yes, I am.
I do see a lot of correspondence between you guys, but the correspondence that's in writing is you or Mr. Brody saying that's not required by the law, and we're not going to make people wear masks. So he is saying that there was a verbal conversation between you and Ms. Crawford, wherein you tell Ms. Crawford, sure, no problem. Tell me about that.
Every time Mr. Brody gives me notice that a tenant is going to vacate, I call the tenants the next day, meaning I spoke with Ms. Crawford on June 27th, and I did explain that all of the showings will be conducted. I don't do any showings without someone not having a mask.
Well, then why is Mr. Brody telling, I'm sorry, hold on. Mr. Brody has emails. If you're saying that as soon as she gave notice, you told her that, Mr. Brody's saying, you know what, I'm not going to quote Mr. Brody from memory. I'm going to quote Mr. Brody. This one's from Mr. Brody at 6 p.m. Showings can be conducted. We'll be abiding by social distancing. Just don't go within 6 feet of any prospects or Gladys. Additionally, you don't need to be home during the showing. You will get notifications regarding each showing. If you're scared, you can leave the apartment for the duration of the showings. Your request that we wait is being denied as deemed selfish. Because you're scared, I should lose $875. Because you are scared, you should just walk out of your apartment for a few minutes. Also, out of the 20 move-outs I did since coronavirus began, you're the first person to think I shouldn't conduct showings. So you get told that you're going to be charged a fee, because in your lease it says if you violate any provision, you will be charged $300, which, Mr. Brody, is genius. I have never seen anything like that. I have been a judge presiding over these cases, reading leases. I have been a tenant. I have been a landlord. I have never seen anything like that. And you signed that lease. It says specifically you're getting fined. We're having a fining system if you violate the lease. So he tells you, you have an obligation to let us show the place. You're not letting us show the place. If you don't let us show the place, I'm going to charge you $300 for each time that you violate that part. And your response to that is what?
Just said okay.
Yeah, you didn't debate with them. All right, so now, Gladys, you send a text to her telling her, please be on notice that we're going to show the apartment. The first one is giving her 24 hours notice. That sounds reasonable to me. The second one is giving her 4 hours notice. 4 hours is an appropriate notice. Someone called you and said, hey, come into your house in 4 hours, clean it up, and that's kind of not okay. So in any event, what happens is that you send an email saying, I'm not letting you in and you're not showing it to anybody either day.
Yes, for the 6/29 showing.
Okay. All right. Mr. Brody, you feel you haven't had a problem with other tenants. You feel like she's creating a problem because she just doesn't want to let you show it. So let me give you the floor. Talk to me.
Okay. So first of all, this was an evolving situation. However, over the course of time, there's a lot of time that transpired between my initial email and follow-up conversations that I had with Gladys, Gladys's conversations with the tenant, my verbal conversations with the tenant. We evolved. And of course, very quickly, I backed down because, as you pointed out, masks are they're fairly nominal, and why not? And then we agreed to everything, right? Now, it wasn't really an agreement because Ms. Crawford didn't agree to it. However, something that I really very strongly believed is that Ms. Crawford, a showing does not take a very long time. This is a very small apartment. Her whole apartment was about 700 square feet, right? It's a 2-bedroom apartment. You really walk in, walk out. 5 minutes is a very long time. That's if somebody's going to be going through the nooks and the crannies. It generally takes less than that. If we give you enough notice in advance, send a text message 1 hour in advance, call you when we're outside. You could go out to the common area, wait for 5 minutes, and we'll be back, and we'll call you when we leave the apartment, right?
Right, but you understand that you can't give someone 4 hours notice. That's not, under the eyes of the law, that's not reasonable. You have to give them like 24 hours notice.
So in the eyes of the law, there's no amount of time that's stated.
There isn't. Who gets to decide it? The judge, when it all hits the fan. That's who decides what's reasonable. And during a pandemic, I don't think less than 24 hours is reasonable, especially when people are working at home. She's working at home. She'd have to find, hold on, let me finish. She'd have to find alternative arrangements. No, I find that 24 hours, because the law doesn't fix the time, so I'm supposed to decide what is reasonable in an exact circumstance. In this circumstance, I don't think less than 24 is reasonable. She wants you to pay for her U-Haul. She wants you to pay for pain and suffering. And she wants you to pay, what's the other thing you want her? Oh, you want the money back that he kept for damages. Is that correct?
Yes.
Okay, so let's talk about the damages first. I have pictures that you have submitted about the damages. What is this a picture of right here?
That's markings on a wall that she defaced my wall.
And what was that? That she nailed something in, or?
Yeah, well, I don't know what the act that she did was. I wasn't present.
Your Honor, I'm honestly not sure where in the apartment that wall is or what those markings are.
Okay, what happened on, what am I looking at here, Ms. Crawford? That looks like certainly $300 and something worth of damage, which is what he kept from your security deposit. I mean, you can't turn it, you didn't get it that way, so why would you return it that way?
Some of the markings he took pictures of are from previous tenants, and we have photos to...
Yeah, here's how it works, though. Yeah. You're going to have to prove that, because this is a place that's run like a Swiss watch. You know, they're very bossy. They got lots of rules, and they're entitled to it. It's his property. He can decide how he wants to run it. He's got a property manager. She's on it. So if you're going to tell me that you moved into a place that looks like that, you better be able to prove it. Every tenant and every landlord, before and after any tenancy, the tenant should be taking close pictures of any damage and sending it to the landlord and saying, I'm not complaining, I don't care, or yes, repair this, or whatever, but I don't want to get blamed. But you're not going to be heard to say later on a place that runs like this. So no. As far as the $391 that was deducted for repairing the walls, I find that was appropriate. You are suing for $800 collection amount. All you have to do is contact the credit bureau and get it cleared up. In fact, yours is already cleared up. I think your mother's is still pending, or the other way around. But that's going to be cleared up. You're not going to get $800 for that. And then why would Mr. Brody be responsible for paying your movers?
Because that was a result of pain and suffering, having to abruptly vacate the apartment due to concerns.
Well, no, it's separate from your pain and suffering. Your pain and suffering is $3,593.10 to get you to the statutory maximum of $5,000. Listen, folks. I know everybody's mad at everybody. I think I got this, and I've got everybody's number here. Mr. Brody, if a showing happened and you re-rented it, why you didn't leave just well enough alone and move on is beyond me. But you put it on their credit report and basically said, take that. And then she filed a $5,000 lawsuit against you. And she said, no, you take that. I'm suing you for $5,000. I assume that you are a businessman with better things to do than sit through this trial. Think about that the next time, and maybe we don't end up in this position. It's up to you. I don't care. I got to be here anyway. All right. So, Ms. Crawford, let's start with your lawsuit. On your lawsuit for $5,000 against the landlord for pain and suffering, the U-Haul, the monies withheld from security deposit, I am finding in favor of the landlord and not of you. We are done. That is my verdict. I wish you all very much luck.
So the plaintiffs fail in their effort to get $5,000 out of the defendant in this case. Ms. Crawford, Ms. McDonald, this is your chance to tell me how you feel about that.
I can respect the judge's verdict. However, I did have something to say that I wasn't able to say. He also went on to say that he will ruin my credit and ruin my life.
The judge didn't think that was very fair of him to do that either, and she admonished him for that. Ladies, you lost the case. I'm sorry, but that's the way it is. Mr. Brody, let me ask you about the judge's decision. What the plaintiffs just had to say. Did you hear that?
There was a lot said back and forth in the beginning of the dispute. In no way did I meet it in any sort of way other than just in the height of a fight. I didn't, I lost myself for a moment at that time, but of course the judge saw the truth right through this ridiculous $5,000 allegation, which had no merit and no basis, nearly made the judge laugh when she finally understood what was going on over here.
That'll do it for this case. Harvey, what do you think?
Doug, I have to tell you, I think this is a really interesting case. COVID has raised so many legal issues that have been untested in the courts, and judges are trying to navigate through this just the way everybody else is. I mean, this is a situation where the plaintiffs easily could have left the apartment when the prospective tenants came in to look, and it would not have compromised their health. So they didn't do that. As a result, they lost the case. But I will say there are a lot of COVID issues that have been unresolved in court, and my guess is we are going to be seeing these cases not just in the next week or months, but probably years.
Hey judges, my neighbor cut the roots of my tree, which were growing onto his property, and my tree died and fell on his house. Who's responsible for the damages? Thanks, Carissa.
First of all, when a tree is partially on one person's property and grows onto another person's property, either because the limbs are, either the limbs are, it's from hell to the heavens.
Right.
You have a right to the use of your own property, and if those limbs are coming over, you have the perfect right at your own expense to cut those limbs, and if the roots are invading, or you also have the perfect right to cut the roots. Now, there are all kinds of things that could have been done to prevent what happened, but now what happened happened. And so the issue is, does the person asking the question have any liability for that? And the answer is, unless the person who cut the roots can prove that the person who owns the tree has something he ignored doing, some duty he ignored doing, like the tree was decaying or whatever else, no!
You're out of luck.
If in fact it tipped over because it no longer had its root system,
Right.
then heck no. No, you don't have to pay for it.
Right.
That's going to do it for this session of the People's Court. We'll see you next time.